All right, good afternoon, everyone. I'm Lieutenant Trainer with the Melbourne PD Peer Support Team, and with me is PBA attorney Greg Forehand, and we are going to give you guys some tips and sort of a quick overview of some estate planning, wills, and other consideration. As we have gone into this COVID-19 pandemic, I think it's sort of brought to the forefront for everyone the need to have some additional planning, the things that you may not have thought of, but are very important for all of our families, whether you have children, whether you're married, but the families that would remain need to have some security. And so for us to do the best that we can to set up legal paperwork and guidelines of how to handle, unfortunately, a death situation for all of us and how to keep them prepared and receiving the benefits that they need to get. So I'm going to talk about some of our EAP benefits that are available to us, and Greg's going to talk about some specifics, advice that he's learned over the years and how we can best prepare. And I thank you for coming in, Greg. I'd shake your hand, but here we are, and that's what we're talking about. So thanks for coming in. I can let you kind of go through the list if you'd like, if that would be easiest.
Okay. First and foremost, I understand you guys have a program to help you draft a will. Wills are important. We'll go over more in detail, but the most important thing to make the will legally enforceable is how you execute the will. And by execute it, I mean how you sign it. Long story short, you're going to have two witnesses. You're going to have a notary and yourself. All four of you need to be in the same room, and all four of you need to see each other sign the document. Once that's done, that's the only legal requirement as far as executing the will goes. But I can't stress to you, somebody can't be in the other room. You can't have somebody walk in and say, hey, did you sign it? Yeah, I signed it, and then sign it. Everybody has to be in the same room together. Florida is very strict about that, and if you don't do it that way, your will can be struck down. The next thing is, once you've executed the will, where are you going to keep it? Obviously, you want to keep the will somewhere safe. Unlike a lot of documents, the will original is worth its weight in gold. Copies can lead you into lots of litigation. So keep it in a safe place, keep it where your loved ones are going to know where it's at and where they can lay their hands on it quickly. Once, God forbid, you pass away, the will needs to be taken down to the clerk of the court. They usually have a probate division at the clerk's office. You walk in, you say, I have a will I have to file. They'll take the will from you. They'll give you a receipt for it. Now, the court has the will, so if anybody ever needs to probate the will, it's there and can be taken care of. The other thing, by taking the will down right away, it eliminates any claims that 30 years from now when you pass away that will is a forgery. Obviously, most forgeries, somebody dies and then a month later somebody forges a will. So get it down to the clerk of the court as soon as possible. The next thing, a lot of wills in Florida statute 732.515 is a section that allows you to, in addition to your will, make a separate writing where you list individual items you want to give to people. So you've got your will, and let's say you want to give certain little keepsakes or something to different family members, like you want to give an heirloom porcelain figurine to a daughter, or you want to give something else to family members. You can write out a list, sign it. It doesn't need to be executed like a will, but it will control where those things go to. A good example of this is where mistakes are made is it has to be a physical thing. You can't write out a separate list saying I want $500 to go to my cousin. It can only control actual physical items you can grab a hold of, like the phone, and it only controls things that don't represent something else. So if I have a stock certificate that says I own 500 shares of Walmart stock, I can't say I leave my $500 stock certificate to my cousin. You can only be physical items that have value in and of themselves, okay? Towards that end, I see a lot of people who take the time to come up with a will and leave things to certain family members. And having been practicing and probated wills and dealt in that area for about a decade, I can tell you that the will is a piece of paper, and that separate list you write, they're just pieces of paper. If you want a family member to get that heirloom keepsake, I recommend a lot of times you give it to them while you're still alive. And the reason is, unfortunately, I've had numerous calls in my practice where father dies and first one in the house takes everything that they want to take. So you can have a piece of paper that say you get it, but that doesn't mean you're going to get it. Things disappear when people pass away, unfortunately. So if you do want somebody to get something, give it to them while you're still alive. You get to see their face light up and enjoy the item, and you'll know they're going to get it that way. Probating. Probating is nothing more than a court proceeding for handling, getting all the assets from the deceased person's estate, getting it together, paying off the debts of the estate, and then paying out what's left to the beneficiaries. A lot of people think that if, for example, you have a will that leaves me as your personal representative, that as soon as you die, I'm the personal representative and I can go take care of business. No. What happens is the will gets filed with the court. Somebody has to file a petition, which is essentially like a lawsuit with the court. And once everything has been done in accordance, the court will appoint the person as the personal representative. So a personal representative, they have no power until that is done. If your person's estate, when somebody passes away, has debts, the common practice in the field is you wait 2 years before you probate an estate. And the reason you do that is the parties that can probate an estate are the beneficiaries, also the creditors. And so if the creditors don't probate your estate, let's say you owe, $200,000 to a hospital or whoever, they traditionally don't probate estates. So what your attorney will usually be telling you is, hey, don't probate the estate. After 2 years, creditors' claims are all extinguished. You can probate the estate so all the estate doesn't go to the hospital to pay for bills or something like that. What does the probate control? What assets? Your will. It says people get certain things. Well, what does your will control? There are some things it does, and more importantly, a lot of things that it doesn't control. For example, if you have a bank account, when you went in and you opened up your bank account, a lot of times they gave you a form where you could list a beneficiary, okay? If you listed a beneficiary, when you pass away, that person, if they walk into the bank with a copy of your death certificate, the bank's going to give them that money, okay? They're not going to wait till a personal representative comes along and says, I'm the personal representative, give me the money. They're going to give it to whoever is on that. So essentially, that money is not part of your estate, okay? So it's very, very important to any of your bank accounts, any of your financial accounts, make sure that that stuff's up to date. How many times have we seen somebody dies and, well, they did that paperwork when they opened the account when they were married to somebody else before, and now you pass away and your ex-wife runs down to the bank with death certificate and gets all the money you wanted to go to your new wife. So make sure that stuff's up to date. It's really important. Again, for a lot of the different things, all you need is a copy of the death certificate, not the will. If you do everything right, the will's there as a safety, as a backstop, but if you do everything right, you may never have to probate your will, which saves you a lot of time and a lot of money. Okay, so for all of your financial accounts, see if there's any forms you can fill out to list a beneficiary. The nice thing about that is, if you can, there is no probate delay. Court proceedings take forever. If you can get the death certificate, walk in and claim the money when you really need it, that helps out families quite a bit. Life insurance policies, we had an officer in an agency where his ex-wife was listed as the beneficiary. He was in a bad crash, almost passed away, and his ex-wife was going to get a payday. Luckily, he survived, and that didn't happen, but lesson learned for him. Please don't learn that lesson the hard way. Another thing that doesn't go through an estate usually is a lot of times real estate, and real estate especially being your home. Most of us, when we buy a piece of land, our house, and we're married, we take title to that house in what's called tenancy by the entirety, which means your house is in both your husband and your wife's name, and you'll know it's that when it says grantor, whoever is the grantor conveys to you Joe and Jill Smith as husband and wife. If you see that language in the deed, that means that both of you own it. It's your marital property, if you will. When one of you passes away, the other one owns it instantly. There's no court proceedings you have to go through. A lot of times you may have to take the death certificate down to the tax collector's office so that future taxes only get sent in the survivor's name, but there's no legal proceedings that have to be done. And I would recommend that if you're married and you take title to property, take it in both names for that very reason, because if you just have title in one name, then that could force you to have to probate an estate, which takes time and money. As you get older, and I'm talking way old, like even older than me, there are ways that you can come up with creative deeds. There's one called the Ladybird deed, and what those deeds do, it allows it to set up a deed where when you pass away, the property instantly goes to whoever you want it to go to. What a ladybird does is, let's say I have 3 children and my wife's already passed away, and I know I'm not going to be around forever. I can create a ladybird deed that lets me own it for the rest of my life, and the instant I pass away, my 2 children would instantly own it. And again, all they would have to do is take the death certificate down to the tax collector's or the appraiser's office, and they'll get that taken care of. Vehicle titles, another area where people can get in trouble and maybe have to probate something is if you've got a title to a vehicle just in one name. If you're married, there's a provision, even without a will, to go down to the tag office, fill out an affidavit saying, hey, that's the family vehicle, we need it, and they'll transfer without doing it. But if you've got a nice, a sports car or something you want your wife to have to get without having to go through any problems, if you're married, please put things in both names. And then don't forget on the title, if it says John and Susan, then if you want to sell that or do anything else with it, you both have to be there to sign the title. If you use the word or in between, John or Susan, then one of you can go down to the tag office and sell the vehicle or take care of it without both of you having to be there. So don't forget, and they'll ask you that a lot of times at the tag office, you want an and or an or in there. Trusts. Not many of us have trusts. I think trusts are way overused for most people. Trusts are very beneficial. For example, if you have a special needs child that will never be able to take care of themselves, a trust can come in very handy to put the money in the hands of somebody who can take care of it and take care of the individual. Too often I see lawyers selling trusts that don't need to be. And so if you've got a trust, you got to ask yourself, why do you have it? But to let you know, anything that's in a trust, and I'll give an example, my older brother, he's got a piece of land in a trust. Well, anything in a trust isn't part of his estate. Trusts live beyond the life of people, and they last as long as whatever the trust says they last. So some trusts are set up to say that when you die, everything in the trust goes into your estate. Okay, now you're going to probate it. Most people use trusts so that they put their house in the trust and it says when you die, your son gets it. Okay, and if that's what the case, when you die, your son gets it. Well, I see a lot of people, they'll update their will because for whatever reason they don't want their son to get it, or God forbid their son has passed away first. They don't update the trust, they just update the will, and now once again you're back in that same situation, which you want to avoid. One of the big implications is taxes. Every year Congress changes what the estate tax is. We're talking millions of dollars. Usually it's about $2 million. So if you're lucky enough in your career in law enforcement to sock up over a couple $1 million in assets, I would tell you go talk to a professional estate planner. Don't do it on your own. But again, we're talking at this time $2 million, and it'll go up and down, but it's usually never going to be under $2 million. There are also in times tax code changes. You don't know what they are now, but stay conscious. If there's ever a big change in the tax code, it's usually all over the news and you usually hear about it. And at that time, you may need to make some changes. One of the things that I saw, and you need to remember, is as your parents pass away, you as the beneficiary of a will or as the heirs of your parents, you've got no duty to pay the debts of your deceased loved ones, okay? I've seen numerous times where people called up and a creditor's called up and said, hey, it was your father, you owe that money, we're gonna come take your house unless you pay that money. No, you have no responsibility at all to pay anybody else's debts unless, for example, you signed as a co-debtor on a loan or something like that. But the mere death of a loved one doesn't mean you have to pay any of their debts. Durable powers of attorney. A lot of people think durable power of attorney means that, hey, my dad gave me durable power of attorney to transfer title to this car. He passed away. Now I can use that durable power of attorney. No, durable power of attorneys cease to be the instant the person who gave that power passes away. So don't think of a durable power of attorney as an estate planning tool. It's not. You want to keep your will up to date with the big changes. And the big changes are you marry, you remarry, you have new children, or you adopt children. You divorce, and I have seen cases where people marry, second marriage, child's 1 year old, and the in this case the new husband raised that as his own child, and he wanted that child to get a share of his estate, but he never went through the legal proceedings to adopt the child. And in that case, in Florida law, if you pass away and you don't have a will, and let's say you don't have a spouse, your property is going to be divided evenly among your legal children, and your legal children are the ones that are your birth kids or the ones you adopt, nobody else. So if you want somebody else to get something, you've got to do a will. Obviously, if you strike it rich, if you win the Powerball, go see a tax attorney, and you're going to have to revisit your will in a big way. If you get any real estate or other really valuable assets in other states, Florida's probate law controls what happens to assets here. If you have land in another state, you'll have to do what we call an ancillary administration, which means probating it again there under their laws, whatever their laws are. I will tell you though, if you came down to Florida and you had a will valid in another state, that will is still valid here in Florida. But don't forget to update. And then the last most important thing, I know I've thrown a lot at people, and I can give people a copy of this outline. As you get older, you're going to be lucky enough to have grandkids like me. Do not leave your grandchildren anything. Okay, how heartless can you be, right? The reason is, by the time hopefully you pass away, your kids are going to be in their 50s or their 60s, and they're going to be set and they're going to be responsible. If you give $100,000 to a 60-year-old person, when they're 10 years later, they're going to have turned that $100,000 into $120,000. You give $100,000 to a 20-year-old, and they have turned it into absolutely zero. So if your kids, I hate to say this, but your kids, they're adults, they're older, they're responsible, they're not going to be turning to drugs or marrying the wrong person or something. Leave it to them and let them take care of your grandkids. And now I'd ask if there are any questions, but you're not here because of COVID. So